Grishma was given capital punishment for killing her boyfriend by a Kerala court. Akshay, Pavan, Vinay and Mukesh were given the death sentence by the Supreme Court in the Nirbhaya case. And Dhananjay Chatterjee was awarded death sentence by the Alipur Sessions Court for raping and murdering a teenage girl. All these cases were considered rarest of rare by the courts. Now, what is a rarest of rare case? Let me explain. A court may decide to award the death penalty when the crime is so heinous that life imprisonment is deemed insufficient. The Supreme Court of India formulated the rarest of rare doctrine while delivering a judgment in a 1980 murder case. So, murders that are pre-planned, diabolical, involve exceptional depravity, or target public servants, police officers, or armed forces on duty may be classified as rarest of rare. In some cases, factors such as age, mental state, or potential for reform may or may not reduce the sentence depending upon the brutality of the crime and the shock it causes to society. One of the examples of rarest of rare cases was the 1990 Dhananjay Chatterjee case. So Dhananjay, who worked as a security guard in Kolkata, was convicted of rape and murder of an 18-year-old schoolgirl in an apartment. The Supreme Court termed it as a rarest of rare case, saying the act committed by the appellant is of a nature that shocks the collective conscience of society. Such a brutal, heinous act falls in the category of rarest of rare cases where the death penalty is warranted. On 14th August 2004, Dhananjay was hanged to death. The 2012 Nirbhaya case was also considered as rarest of rare by the Supreme Court, calling the act brutal, diabolic, and a case that shocked the collective conscience of the society. A judge said if the dreadfulness displayed by the accused in committing the gang rape, insertion of iron rod in the private parts of the victim does not fall in the rarest of rare category, then one may wonder what else would fall in that category. The death sentences of the 4 accused were executed on 20th March 2020. In a more recent case in Kerala in 2025, 24-year-old Grishma was sentenced to death for murdering her boyfriend Sharon Raj from Thiruvananthapuram. A Kerala court described the case as rarest of rare, considering it to be diabolic and depraved. So, 3 years ago, in 2022, Grishma was 22 years old and was in a relationship with 23-year-old Sharon. Grishma wanted to end the relationship because her family had arranged a marriage for her with another man from Kerala, but Sharon refused. So Grishma hatched a plan. On 14th October 2022, when Sharon visited her home in Tamil Nadu's Kanyakumari district, she gave him a poison-laced Ayurvedic drink. As soon as Sharon left her house, he started vomiting, and for the next 11 days, he fought for his life in the ICU before passing away due to organ failure. Grishma was arrested on 31st October 2022, along with a mother and uncle, who was also accused of being involved in plotting the murder. The prosecution said that Grishma had tried to poison him by mixing paracetamol tablets in juice in August 2024. But Sharon didn't drink it as seen in this video. The court said, only a cunning and cruel criminal can repeat the offense. Such a person cannot be reformed. There is no guarantee that she will not mix poison again in any other relationship. Since Grishma was the youngest woman in Kerala to be sentenced to capital punishment, the court stated that her age should not be considered when determining her sentence. Grishma's uncle was sentenced to 3 years in prison for destroying evidence, while her mother was acquitted due to lack of evidence. In the Argical College case, a session court in Kolkata sentenced the convict Sanjay Roy to life imprisonment along with a fine of 50,000 rupees for rape and murder of a junior doctor. While the prosecution demanded the death penalty, the court stated that the crime doesn't fit into the category of rarest of rare needed to award capital punishment. The court said, considering the overall facts and circumstances, we hold this is not a case where the possibility of reformation is completely ruled out. It would be inappropriate to accede to the prosecution's request for the death penalty. The court's duty is to pass a sentence that is proportionate. The victim's family expressed disappointment with the court's decision and dissatisfaction with the investigation.
सीबीआई कोई जो एविडेंस सामने नहीं ला सका उसको कोर्ट ने बोले ये रेयर ऑफ रेयर केस इसलिए उन्होंने बोल दिया.
Following the sentence, on 21st January 2025, the West Bengal government moved the Calcutta High Court seeking capital punishment for Roy.